that, bitch. Courtroom, man. You right. Nigga, 20. Right.
Even though we give them a monetary value for restitution, you can't replace the actual items that have sentimental value. Simply the feeling of being violated in that manner. Obviously, the defendants were part of organized criminal activity. We had Ms. Medina who gave information to Mr. Bynes. Mr. Bynes who had Mr. Grimes come with him, so there would be two, and there would be sort of a heavy person as well as the person with the gun, and individuals present to over one or whomever else could be in the trailer at that time. So they all worked together to facilitate the offense, and the knowledge that Ms. Medina had regarding Mr. Gonzalez transferred down, so the knowledge of the victim and the relationship did facilitate the offense. When we look at recidivism factors, there's even a larger concern of what we're looking at. The defendant has a history that includes numerous juvenile adjudications going back to 1999. I won't go through all of them since they are laid out in the memo, but I will point out that in 1999, he already had a domestic violence and a felony theft. 2000, more thefts and F2 burglary. 2002, we have assault. 2003, multiple thefts and falsification, already showing crimes of deception as well as violence. 2004, there are two separate felony drug abuse cases and an assault case. He becomes an adult in 2005, and his history of adult criminal convictions begins. Again, just pointing out some negative highlights, I suppose. In 2005, we have more thefts, assault, resisting arrest, probation violation. 2006, there are more thefts. 2007, more thefts. 2008, thefts. 2009, felony receiving stolen property. 2010, and that property was his first prison sentence. 2010 was theft with probation violation and also attempted robbery count 4. That was another prison sentence. 2012, multiple thefts, assaults, felony attempted receiving stolen property, felony assault with a probation violation. 2014, felony receiving stolen property, felony robbery, which is written on those. He gets out of prison approximately November 15th of 2017. Then we have 2017 theft, and in 2018, while he's on CPRC as well, attempted vandalism in April 2018, and theft in July 2018. And then this incident is also the beginning of July. He also, as a juvenile, went to Department of Youth Services, which you sort of think of as juvenile prison. He has 4 prior prison terms as an adult on 5 separate cases. He was placed on 3 years of post-release control when he was released in November 2017. So he was on post-release control at the time of those offenses. As of today, he has 623 more days on post-release control. And though today he has, and he has not responded favorably to sanctions previously imposed, with probation violations, contempt charges, parole violations, and obviously he has continued to commit crimes, not stopping that one. And the state would argue that he has no genuine remorse. He didn't take responsibility. And today, if I heard correctly, he apologized to his family, but not to the individuals he heard, specifically in the trailer and the trailer's owner. There was also a comment made about what one of the co-defendants got, and that similar crimes and similar defendants, similar sentences. However, as I would imagine the court is aware, that doesn't mean numerical comparison. It specifically means looking at all the factors and purposes and principles, which this court does in every single case, to look at those cases to what should be done in that case. Numerical comparison has been found not to be appropriate throughout this district and others. So we do feel that prison is obviously consistent. There's a presumption for prison in both counts 1 and 3. And there are gun specifications on those as well. We feel that any sentence that this court does render should be prison, and they should be consecutive sentences. The serious nature of what occurred in this case is to mean not to do prison or to do consecutive sentences. We also need to protect the public from future crimes, as well as to punish the offender. And what he did was quite horrible and horrendous for those involved. In addition, as stated, he was under post-release control, and his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime values. So based on all that, we do feel that prison is appropriate, that all prison sentences should be consecutive, and that we feel at least 20 years would be appropriate at a minimum. We would ask for the forfeiture of the pistol and the ammunition. We ask for restitution to Mr. Gonzalez in the amount of $1,398. And as this person is aware, the PRC would be mandatory in 5 years. That would be the state's recommendation.
Does the state have any witnesses?
No, Your Honor. The victim impact statements that you received, they did not.
The court has considered the record, the oral statements made, the victim impact statements, the trial testimony and evidence, the pre-sentence report from several years ago, the updated criminal history, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. The court has also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local governmental resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've considered the recommendations of the parties, including the sentencing memoranda. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code 2929.12. In that regard, there are factors making the offenses more serious. The victim suffered serious psychological and economic harm. And I'm talking about Mr. Gonzalez. I believe he needed psychological treatment as a result of this. The economic harm was substantial. The Murillos suffered significant psychological harm for the home invasion that occurred as they arrived at their place of residence. The was committed as part of an organized criminal activity. There were 3 people involved in this. There are no factors making the offenses less serious. In terms of recidivism, the offenses were committed while on post-release control from the previous time that I sent the defendant to prison for a crime of violence. The defendant has an extensive previous criminal history and history of juvenile delinquency. He's been to prison 3 times on 4 cases. He's got 9 prior crimes of violence before this case. He's got 11 instances of probation violations, resisting arrest, obstructing justice, and contempt of court, and numerous convictions. He's been arrested on 4 other crimes, plus this case, while on post-release control. The defendant was placed on PRC on November 15th of 2017, a 3-year period and yet committed this offense less than 8 months later. There's a pattern of drug or alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment. There's been a rehabilitation failure after previous convictions and delinquency adjudications, and a failure to respond in the past to probation or post-release control. The court determines that the offenses were committed under circumstances very likely to recur, and the court determines to make recidivism less likely that the offender shows a certain amount of remorse. The court determines, though, that the defendant poses the greatest likelihood of committing future crimes. On the felony 4, the CCW, there is no presumption in favor of community control because of the PRC violation and the prior prison terms, and because it was possession of a firearm. On the 2 felony 1s, there is a presumption in favor of prison, and there is not a lick of evidence here by which the court could override that presumption in favor of prison. The court determines that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. The court believes that consecutive sentences are necessary to protect the public and punish this offender. They would not be disproportionate to his conduct and the danger he poses. That the crimes were committed while on post-release control. That the harm is so great or unusual that a single term would not adequately reflect the seriousness of his conduct, and his criminal history shows that consecutive terms are needed to protect the public from future crime. Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. The court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days, according to the DRC's calculation. Court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years, and 3 years on the firearm specification. Court sentences you on count 3, aggravated robbery, felony 1, to a period of incarceration in state prison for 8 years, plus 3 years on the firearm specification. The court sentences you on count 6, weapons under disability, felony 3, for 36 months. And on count 7, CCW, felony 4, for 18 months. The court makes the 2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges, the offenses. However, the court makes the 2 F1s consecutive with one another, and therefore the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years with credit for 231 days. The court determines that you have or will have the ability to pay restitution. Court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed. He poses the greatest likelihood of recidivism. So I believe I stated that restitution in the amount of $1,298 to victim Arturo Gonzalez, judgment rendered for that amount to be monitored by the Ohio Adult Parole Authority, payable through the clerk of courts. Defendants to forfeit all items in the specification, being the pistol and ammunition, to pay the costs of confinement, prosecution, supervision, treatment, and court costs. Upon the defendant's release from prison, to be on a mandatory non-reducible period of post-release control for 5 years, subject to the jurisdiction and control of the Ohio Adult Parole Authority. Can return him to prison for up to 9 months for any one violation, and up to 1/2 the original prison term for all violations in the aggregate. All of that time is part of the sentence. Should the violation of PRC be a new felony, the judge in a new felony case, in addition to sending him to prison on the new case, can send him back to prison on this case for the greater of 1 year, or whatever length of time remains unexpired on that mandatory non-reducible 5 years. All of that time is already part of the sentence. The defendant may be eligible to earn some credit against time to be served on the non-mandatory portions of this. The non-mandatory portions would be counts 1 and 3, the mandatory portions being the PRC and the 2 gun specs. The credit is capped at 8% of time to be served, as long as the defendant owes court costs, stake and block his motor vehicle registration, court opposes shock incarceration or intensive prison program. Bond, if any, is released. The defendant is ineligible for judicial release, and the time period for counting judicial release eligibility does not count during the mandatory times, which would be the PRC and the 2 3-year gun specs. Court will appoint counsel for appeal. If you want to think about whether you want to handle the appeal, and let me know. If you don't want to handle it, then I will appoint another private attorney to do it.
Excuse me, I think you can answer that now. We would prefer that someone else do the appeal in the event that our performance was deficient.
All right.
And that may be an issue.
New counsel will be appointed for purposes of appeal. An appeals bond is obviously denied. The defendant has a right to appeal any of the decisions I've made in this case and the jury's verdict, filing a notice of appeal within 30 days after the date that my order is journalized. My order will probably be journalized no later than Monday. Just to give you an idea as to the running of the appeals period.
Would you like us to file a formal motion for appointment of counsel, or will this suffice?
This will suffice. We have a list of counsel that wants to do appellate work, and we can appoint somebody based on that. So I'll appoint somebody probably within the next week so that they can make appropriate arrangements so that the time period doesn't run without something being done. Mr. Emil?
Just one additional thing, Your Honor. Would you make a specific finding of indigency for purposes of submitting the fee bill in this case, because I don't think it's a good idea for me to go ask for a signature on the affidavit of indigency I have.
The defendant is indigent, and the court will pay counsel's fees according to the fee schedule set forth. He seems so calm and cool and civil until the sentence. All right. So for purposes of the entry, you got the order that they're to be served.
PRC, spec on count 1, spec on count 3.
Right. And I'm merging the 1-year specs into the 3-year specs.
Right.
But I'm sentencing on 2 3-year specs.
And the specs are consecutive, counts 1 and 3 are consecutive, 6 and 7 are concurrent with each other, and the
Right.
I believe I have.
And was it, you're on just 11 on counts 1 and 3 then, from the, you originally posed 8, but then I believe.
Right.
in precinct
Right.
11.
Yeah, I apparently thought that he was more remorseful than what he was, that he was just feeding me a line of bull. And, you know, the court, it wasn't on the record, but the last time, as he was walking out of the court, he said, "Suck my dick, Judge." So, this seems to be a repeat pattern with him. Anything else?
Not from the state.
Nothing, Your Honor, thank you.
Probation have anything to say? Good probationer for you?
Yeah, sure.
All right, we're adjourned. Thank you for handling this case. It was tough getting attorneys that would stay on to represent him, and regardless of the result, you guys did an admirable job. What were you going to say?
Is the court's fee schedule memorialized anywhere? I haven't been able to find it in the rules or anywhere.
The fee schedule is 40 out of court, 50 in court. I will permit extraordinary. I won't cap it. Doesn't mean that I might not reduce it after I see it, but I'm not going to limit you to the F1 cap because he was a handful.